My husband had been dead for 11 days when a judge ordered me to remove the medal from my uniform. I had come straight from a memorial formation at the base. There had been no time to change, so I stood beside my attorney in service dress, my black morning coat folded over one arm. Across the courtroom, my mother-in-law watched me with a small, satisfied smile. Eleanor Brooks had sued for control of the house Thomas and I had shared for 13 years. Her attorney, Martin Vale, told the court that my uniform was an attempt to influence the room. Judge Roland Keene looked at the medal above my left pocket. "Take that medal off," he said. "This is a courtroom, not a parade ground." Every voice stopped. The clerk lowered her eyes. A man in the second row shifted uncomfortably. Eleanor smirked. I felt heat rise through my chest, but I did not touch the medal. It had been awarded after an evacuation mission that brought 37 people home alive. I had worn it under military regulations. I had not put it on for the judge. Rachel Kim rose beside me. "Your Honor, Lieutenant Colonel Brooks is appearing in an authorized uniform. We ask that the court's instruction be preserved exactly in the transcript." Judge Keene's expression hardened. "Sit down, counsel." Rachel sat. I remained silent. Then I opened my leather case and removed a sealed envelope Thomas had left behind. I placed it in front of Rachel. She submitted it through the clerk. The envelope was not addressed to the judge. It carried an official seal, a preservation notice, and a case number. Judge Keene looked at it once. Then again, the color left his face. Eleanor leaned toward Martin, trying to read the outside. The moment she recognized the seal, her smile vanished. Judge Keene called an immediate recess. As he rose, he pointed toward the clerk. "No copies of that envelope are to be made." Rachel waited until he had left the bench. Then she whispered, "That order just became part of the record, too." Thomas died before I reached the hospital. I had been reviewing a transportation plan at the base when my phone vibrated against the conference table. The emergency physician said my husband had suffered a ruptured aneurysm at his office. By the time I arrived, the room was quiet. A nurse placed Thomas's wedding ring, wallet, and keys into my hands. I was still trying to understand how a man could leave home in the morning and become a collection of personal effects before lunch. Eleanor arrived 20 minutes later. She looked at her son through the glass. Then she asked me where Thomas kept the safe key. Her next question was about the deed. Then the life insurance. She wanted to know whether he had changed his trust. I told her we would discuss paperwork after the funeral. Her mouth tightened. "That house was Brooks' land before you ever appeared," she said. "It belongs with the family." I had been married to Thomas for 13 years, but Eleanor had never stopped describing me as someone passing through. At the funeral, she sat in the first row and accepted condolences like a widow. Before the flowers had been removed, I saw her speaking in a corner with Martin Vale. Thomas's body had not yet been buried. They were discussing how quickly a petition could be filed. 3 days later, the papers arrived. Eleanor asked the court to freeze the living trust, prevent me from selling or altering the property, and give her temporary control of the house. She claimed my deployments proved I did not truly live there. She demanded my financial records. She also described the land as an inherited Brooks family asset that Thomas had only been allowed to use. Rachel read the petition twice. Then she began searching Eleanor's financial history. The reason for the urgency appeared in a loan file. Eleanor's failed housing development was in default. She had 45 days before the lender could begin taking her remaining property. There was also a letter from a developer offering to buy my house and the surrounding land. The offer had been prepared before Thomas died. At the bottom was a promise of a success fee to a consulting company I did not recognize. Rachel searched the company registration. It belonged to Judge Keene's son. Eleanor's lawsuit depended on one lie. She needed the court to believe that Thomas and I had lived in a house that still belonged to the Brooks family. The bank records showed something else. Thomas and I bought the property 2 years after our wedding. The land had once belonged to his parents, but it was heavily mortgaged. Eleanor and 2 relatives still held small interests that prevented a clean sale. We paid each of them to surrender those interests. My contribution came from personal savings, accumulated housing allowances, and money set aside during earlier assignments. Thomas added the proceeds from selling his condominium. The remaining balance came from a loan issued in both our names. Eleanor had her own attorney during the transaction. She signed a family settlement agreement stating that she had received full payment and permanently released every ownership claim. The deed listed Thomas and me as owners. Years later, when Thomas's company struggled, my salary kept the mortgage current. I paid for the roof after a storm. I paid for foundation repairs. I paid for the new heating system after the old one failed in winter. Eleanor still told relatives that I merely stayed in her family's house between deployments. I never corrected her. Thomas hated public conflict. I believed silence protected him. Instead, it gave Eleanor room to repeat the lie until she began treating it as fact. Rachel gathered the deed, settlement agreement, loan records, and every receipt showing payment to Eleanor. Then she examined the affidavit Eleanor had filed. Eleanor claimed she had signed only to give Thomas permission to use the land. She denied selling her ownership interest. The original document used the words final payment, full release, and permanent surrender. Her new story did not match her old signature. Then Rachel found Eleanor's tax return from the year of the sale. She had reported the money as proceeds from the sale of a property interest. Eleanor called that an accountant's mistake. Rachel kept searching. A bank application from 6 years earlier contained the same settlement agreement. Eleanor had submitted it herself to prove she possessed cash from selling her interest in the property. She had relied on the agreement when it benefited her. Now she wanted the court to pretend it meant nothing. Rachel closed the file. She knows exactly what she signed, she said. Then she turned to the developer's offer. The harder question is why Judge Keene appears connected to the buyer. At first, I told myself Judge Keene was simply an arrogant man. His contempt for my uniform felt personal. But arrogance alone did not explain the pattern Rachel began finding. She reviewed his public financial disclosures and recusal history. There was no mention of Eleanor, no mention of Martin Vale, no mention of the developer trying to buy my house, and no reference to the consulting company owned by his son. Then I remembered a photograph. Several years earlier, Eleanor had hosted a charity fundraiser at a private club. Thomas and I attended for less than an hour. Judge Keene had been there. So had Martin. Eleanor later dismissed it as a community event. Rachel searched public photographs from other fundraisers. The same people appeared again and again. Judge Keene stood beside Martin at a housing foundation dinner. His son was photographed with the developer's president. Eleanor sat at their table during a campaign reception. None of that proved corruption. Judges attended public events. Attorneys donated to charities. Families knew one another. But small contradictions began to collect. Judge Keene denied Rachel's request for records connected to the property valuation. He called them irrelevant. He accepted Eleanor's affidavit without requiring the original ownership documents. When Rachel tried to submit my bank records, he delayed them for additional authentication. The rules seemed to change depending on which side offered the evidence. He also refused to address me by my correct title. The case file identified me as Lieutenant Colonel Naomi Brooks. Judge Keene repeatedly called me Miss Brooks. I did not correct him. Rachel asked that each ruling be issued in writing. Each refusal entered the transcript. Each delay received a date. Then, the consulting company owned by Judge Keene's son filed a new business disclosure. It showed a payment from the developer only days after Eleanor filed her lawsuit. The invoice described the service as Strategic Access Consulting. Rachel stared at the phrase. A consultant could charge for analysis, planning, or market research. Strategic access suggested something else. Access to whom? The payment alone still did not prove Judge Keene had influenced the case, but it changed the question. He was no longer merely a judge who disliked my uniform. He was a judge making decisions in a case that could financially benefit his own family. The key to Thomas's safe was hidden inside an old personnel folder. He had placed it behind a copy of my first promotion order. I found it 3 days after the courtroom hearing. Inside the safe were documents I already recognized: the living trust, the family settlement agreement, the original deed. But beneath them was a second file. It contained an independent property valuation that placed the land at almost twice the amount offered by the developer. There was also a flash drive, a certified mail receipt, and a letter addressed to me. Thomas began by apologizing. He wrote that Eleanor's failed development had placed her under severe financial pressure. She had already promised our property to a buyer, even though she no longer owned any part of it. Martin Vale had obtained details from our trust that he should never have possessed. Thomas believed someone inside the legal process was helping them. The flash drive contained a recording. Martin's voice was unmistakable. Once we are in Keene's courtroom, the paperwork becomes manageable. Eleanor asked whether I could stop the sale. Martin answered, "Not if the court decides she is only a temporary occupant." I listened twice. Thomas had not confronted them directly. He had hired an independent ethics attorney. That attorney traced payments from the developer to Judge Keene's son's consulting company. He found photographs, invoices, and several earlier property cases with the same receiver and developer. Thomas submitted the material to the State Judicial Inquiry Commission. The certified receipt confirmed the date. The agency had accepted the complaint and issued a confidential request to preserve records. The sealed envelope from court contained the acknowledgement, the case number, and a copy of the preservation notice. Thomas explained why he had left it unopened. I was to submit it only if Eleanor filed suit. Judge Keene received the case, and he refused to remove himself. The envelope could not decide the property dispute. It could not arrest anyone. It could not remove a judge from office. Its purpose was simpler. It proved they had been warned before choosing what to do next. At the bottom of the letter, Thomas had written one final sentence. Judge Keene received his preservation notice 3 days before your first hearing. He had known the complaint existed. He had known his conduct was being examined. And he had still ordered me to remove my medal. Rachel explained the envelope to me before the next hearing. The seal does not mean the commission has found him guilty, she said. It means a file exists, evidence must be preserved, and everyone named in it has been warned. Inside were 4 items: the official acknowledgement of Thomas's complaint, a confidential case number, a notice requiring relevant communications and financial records to be preserved, and a list of relationships Judge Keene might need to disclose or address. Eleanor's name appeared in the complaint. So did Martin's. So did the developer and the consulting company owned by the judge's son. That was why Eleanor's smile had disappeared. The envelope did not destroy their plan. It removed their ability to claim they had never been warned. When court resumed, Martin asked to approach Judge Keene privately. Rachel stood immediately. We object to any discussion outside the presence of both parties. Judge Keene denied that he intended to discuss the case. Then he called the envelope irrelevant. Rachel filed a formal motion asking him to recuse himself because his son's company had received money from the developer seeking our property. Judge Keene read only the first page. He denied the motion from the bench. He said Rachel was trying to turn a family property dispute into a political spectacle. Then he looked at me. Your military performance will not control this courtroom. I remained still. Rachel asked that his exact words be included in the transcript. He granted Eleanor's request to continue restricting my control of the property. He also ordered the sealed envelope held by the clerk. Every decision was now dated. Every word was preserved. Every refusal came after the notice Thomas had sent. Judge Keene believed he was proving the complaint had no power over him. What he was actually proving was that he had seen the warning and chosen not to step aside. After the hearing, he returned to his private office. He called his son. We did not hear the conversation. We did not need to. The commission's preservation request covered courthouse communication logs. The call began less than 6 minutes after Judge Keene denied the recusal motion, and its number was already part of the record. Eleanor responded to the sealed envelope by attacking the one thing she believed made me vulnerable: my military service. Her new affidavit described me as controlling, emotionally distant, and rarely present in Thomas's life. Martin presented photographs taken during my overseas assignments. In one, I stood beside a military transport aircraft. In another, I attended a logistics conference several states away. He offered the photographs as proof that I did not truly live in the house. Eleanor told the court that Thomas had depended on her whenever I was gone. She claimed I had pressured him into placing the property in the trust. Then she said my uniform was not a symbol of service. It was a tool I used to intimidate anyone who questioned me. Judge Keene allowed every accusation. Martin asked him to appoint a temporary receiver to control the house and the trust, while the case continued. Rachel objected. She explained that there was no evidence I had damaged, hidden, or attempted to sell any property. Judge Keene granted the request anyway. He selected a receiver named Franklin Cole. Martin had proposed him. Within 24 hours, Cole sent me an order demanding keys, insurance files, maintenance records, and access to Thomas's office. Rachel examined his background before I answered. Cole had worked as a consultant for the same developer trying to buy the property. That relationship did not appear in the recommendation Martin gave the court. Rachel filed an objection. Judge Keene refused to remove him. I followed the written order exactly. I gave Cole only the documents listed. Every page was copied. Every key was photographed. Every item was recorded on a receipt that he signed before leaving. Martin later accused me of resisting the court. Rachel placed the signed receipt into the record. Cole inspected the property the next morning. He spent less than 2 hours there. 3 days later, he issued a valuation placing the house and land at less than 60% of the independent appraisal Thomas had obtained. The report ignored recent improvements. It ignored the additional parcel behind the house. It ignored the property's commercial access. Most importantly, it ignored the land's development value. That same afternoon, the developer sent Eleanor a formal offer. The purchase price matched Cole's valuation almost exactly. The receiver had not discovered the value of the property. He had produced the number the buyer was already prepared to pay. I had spent more than 20 years moving supplies through systems where one incorrect date could expose an entire failure. I approached the property records the same way. I placed every event on a timeline. Judge Keene appointed Franklin Cole on a Monday. Cole inspected the house on Tuesday. His valuation document was created on Wednesday morning. The developer's offer was sent Wednesday afternoon. Eleanor received it before Cole's report had officially been filed with the court. That should not have been possible. Rachel requested the report's metadata. It showed the original document had been created from a template used by Cole in several other court-appointed property cases. We reviewed 3 of them. Each case had been assigned to Judge Keene. Each involved an owner described as elderly, absent, confused, or unable to manage property. Each used Franklin Cole as receiver, and each property had eventually been sold to a company connected to the same development group. The language in the court orders was nearly identical. The valuation reports excluded features that increased market value. Then the developer purchased the properties at prices close to those reduced estimates. Rachel hired an independent appraiser for my house. He included the renovated structure, the rear parcel, road access, zoning potential, and comparable development sales. His valuation was nearly twice Cole's number. I created a map of the transaction. Eleanor needed the sale to pay her overdue debt. The developer wanted valuable land at a reduced price. Martin expected legal fees and a percentage tied to the completed transaction. Cole received receiver and appraisal fees. Judge Keene's son operated the consulting company paid by the developer. Every person gained something if the court removed my control and forced a quick sale. Then Rachel found the invoice. The consulting fee was not a normal fixed payment. It was calculated according to the size and timing of the property transaction. The company would receive a larger amount once the developer secured control of the land and obtained approval for the project. The lower purchase price created more profit for the developer. The faster Judge Keene moved the case, the sooner the consulting company was paid. His son did not merely have a distant relationship with the buyer. He had a financial reason for his father's rulings to favor the sale, and Judge Keene had never disclosed it. Rachel did not announce our findings in the courtroom. She sent them through the proper channels. The supplemental submission to the Judicial Inquiry Commission included Judge Keene's comments about my uniform, the transcript of his refusal to recuse, Franklin Cole's undisclosed relationship with the developer, the 2 competing valuations, and the consulting invoice. She also sent the communication log showing Judge Keene's call to his son minutes after the hearing. The commission requested additional records from the courthouse. Judge Keene received a formal notice. He still refused to step aside. Instead, he scheduled a hearing to approve a possible sale of the property. He ordered Rachel not to mention the ethics inquiry in open court. We obeyed. The investigation did not need a courtroom speech from me. It needed clean records. 2 days before the sale hearing, Martin contacted Rachel with a settlement proposal. Eleanor would receive the house. I could keep my military retirement, personal accounts, and several of Thomas's investments. In exchange, I would waive my objections and withdraw all complaints connected to the case. Rachel read the proposal once, then she pushed it across the desk. They still think the inquiry belongs to you. It did not. Thomas had filed the original complaint. The commission had opened its own proceeding. I could provide evidence. I could cooperate. But I could not erase an official investigation because Eleanor offered to let me keep property she had never owned. Rachel rejected the settlement. That was when Eleanor finally understood the danger. Winning the house would no longer end the problem. Even losing the house would not end it. The records would continue to exist. Martin attempted to send a revised proposal later that evening. He attached the wrong email chain. Buried beneath the draft were earlier messages between Martin, the developer, Eleanor, and an address used by Judge Keene. One message discussed how to describe my deployments. Another said the court should focus on my absence rather than the payment records. The final email contained one sentence. Roland will keep the military angle from controlling the room. The message had been sent weeks before Judge Keene ordered me to remove my medal. The morning of the scheduled sale hearing, Judge Keene entered the courtroom as though nothing had changed. Eleanor sat beside Martin with a prepared transfer order in front of her. Franklin Cole had already delivered keys and inspection records to the developer. They believed the hearing was only a final formality. Then another judge entered through the side door. Judge Amelia Grant was the administrative judge responsible for case assignments. She carried a written order. Judge Keene was temporarily removed from my case while his undisclosed relationships were reviewed. He stared at the order. For several seconds, no one spoke. Then he left the bench without looking at me. Judge Grant reopened every motion Rachel had filed. Rachel began with the ownership records. The deed showed that Thomas and I had purchased the property together. The bank statements showed my contribution. The family settlement agreement showed Eleanor had received full payment and permanently released her interest. Her tax return described the payment as proceeds from a property sale. Her old loan application used the same agreement to prove she had received cash from selling that interest. Eleanor claimed she had never understood the document. Her former attorney testified by video. He said he had reviewed every provision with her. He had advised her independently. She had requested one change before signing, proving she had read the agreement closely enough to negotiate its language. Rachel then presented the living trust. The attorney who prepared it confirmed that Thomas had acted voluntarily and with full capacity. The trust was created before his final illness and before Eleanor's financial crisis became public. Judge Grant upheld it. I remained the lawful successor trustee. Then Rachel turned to the attempted sale. She presented Eleanor's debt records. The letter of intent signed before Thomas's death, Franklin Cole's reduced valuation, the independent appraisal, the developer's offer matching Cole's number, the consulting invoice paid to Judge Keene's son, and the email chain Martin had accidentally sent. Martin objected. Judge Grant overruled him. She read the sentence aloud. Roland will keep the military angle from controlling the room. The courtroom became completely still. Martin said the name could refer to someone else. Rachel presented the email address, the scheduling messages, and Judge Keene's communication log. Martin then asked to withdraw from representing Eleanor. Judge Grant told him that withdrawing would not remove his duty to answer questions about the documents he had submitted. Franklin Cole was removed as receiver. The proposed sale was canceled. His valuation was rejected. Eleanor's ownership claim was denied. Her affidavit was forwarded for review because it contradicted records she had previously submitted to tax authorities and a bank. Eleanor turned toward me. You used the army to take my son's family home. I looked at the agreement carrying her signature. My uniform did not take your house, I said. Your signature proved it was never yours. Judge Grant closed the property file. Then she announced that the inquiry was no longer limited to my case. 3 earlier property sales involving Judge Keene, Franklin Cole, Martin Vale, and the same developer were being reopened. Judge Keene's career had not collapsed because of one sentence in one courtroom. That sentence had only exposed the way he behaved when he believed no one could challenge him. The records showed the rest. Judge Keene was first removed from property and probate cases. The Judicial Inquiry Commission requested his disclosure forms, financial records, official email, telephone logs, event calendars, and communications with Martin and the developer. Investigators also examined the 3 earlier property cases. The pattern was almost identical in each one. An owner was described as absent, confused, elderly, or incapable of managing property. Judge Keene appointed Franklin Cole. Cole produced a reduced valuation. The same development group submitted a rapid offer. Martin, or an affiliated attorney, handled part of the transaction. Judge Keene's son's company received consulting payments. None of those relationships appeared in the judge's disclosure records. The investigation also found communications that had never been placed on the official court record. Judge Keene had spoken with his son after denying Rachel's recusal motion. He had exchanged scheduling messages with Martin. He had attended private events funded by people connected to the development group. His son's fees increased when transactions closed quickly. The transcript from my hearing became part of the evidence. The sentence about my medal was not treated as the single reason for discipline. It showed bias. It showed that Judge Keene had agreed in advance to weaken my credibility by turning my service into a courtroom distraction. It also showed his hostility after he had already received notice that his relationships were under review. Formal charges were filed against him. They included failure to disclose financial interests, refusal to recuse, improper outside communication, misuse of judicial authority, and conduct damaging public confidence in the court. Judge Keene was suspended while the case proceeded. Before the public disciplinary hearing, he announced his retirement. He said political pressure had made it impossible for him to serve fairly. Retirement did not close the investigation. The commission published its findings. His name remained attached to every decision he had tried to keep hidden. He lost the bench. He lost the authority that had made Eleanor and Martin so confident. Martin faced a separate professional investigation. Franklin Cole was removed from the court's approved receiver list. The developer withdrew from several pending transactions. Judge Keen's son agreed to return disputed consulting payments as part of a civil settlement. I did not speak to reporters. I did not celebrate outside the courthouse. A judge's fall could not bring Thomas back. It could not erase the moment Eleanor smiled while my service was mocked, but it could prevent the same system from being used against another family. When the investigations ended, I returned to court one final time, not to watch Judge Keen lose anything, to hear what would happen to the home Thomas and I had built. Judge Grant entered the final order several months after the first hearing. Eleanor had no ownership interest in the house. The family settlement agreement remained valid. The living trust remained in effect. I retained control of the property as successor trustee. Eleanor was ordered to pay a significant portion of the legal costs caused by her false claim and her attempt to force a sale. Her affidavit was referred for further review. The developer withdrew its offer. The debt behind Eleanor's plan did not disappear. Without my house to sell, she had to deal with it using property that actually belonged to her. She sold a vacation condominium. Later, she sold her remaining interest in the failed development. I did not ask for punishment beyond what the evidence supported. But I did not withdraw the records. I did not pay her debt. I did not protect Martin. And I did not write a letter defending Judge Keen. They had each been given a chance to step back. They continued because they believed silence meant consent. For a while, I left Thomas's office untouched. His notebooks remained on the shelf. The independent appraisal stayed inside the second drawer. The sealed envelope went into the safe beside his letter and the final court order. I did not preserve those things because I wanted to live inside the lawsuit. I preserved them because Thomas had understood something before I did. A promise could be denied. A memory could be distorted. A record could still speak after the person who created it was gone. I kept the house, but I did not turn it into a monument. I used part of the ground floor for monthly legal and financial clinics for military families. The rest remained my home. Then I returned to my duties at the base. Months later, I attended another formal ceremony. I wore the same service dress uniform. The medal remained above my left pocket. It was not there to answer Judge Keen. It was not there to punish Eleanor. It was there because it had never required either of them to recognize its value. That evening, I returned to the house alone. I placed my keys on Thomas's desk. Beside them lay the transcript from the first hearing. The words were still printed on the page. "Take that medal off." Below them was the final ruling confirming that the house remained under my control. I removed my uniform jacket. I did not remove the medal. Judge Keen believed silence meant submission. Eleanor believed my uniform made me an outsider. Neither understood that discipline is not weakness. It is knowing when to remain still, what evidence to preserve, and which record will still be standing after every lie collapses.